Joel Bryant is a trial lawyer with more than 24 years of legal experience and is a founding partner of Green, Bryant & French, LLP, with offices in San Diego and Riverside counties. Joel is recognized as one of San Diego's top litigation attorneys, handling nursing home neglect, personal injury, financial elder abuse, and will and trust fraud cases. Joel was president of the Consumer Attorneys of San Diego in 2011 and served on its board of directors for 11 years. He is currently on the board of governors for Consumer Attorneys of California and has received its Presidential Award of Merit. Joel is a member of the San Diego Bar Association and has served on its Judicial Election Evaluation Committee and Court Funding Action Committees.
Hello, I'm Joel Bryant. I'm an elder law litigation attorney. I got involved in elder law litigation through happenstance. I had a husband and wife who owned a small residential care facility come into my office. They had been sued for nursing home abuse, and their aunt, a nurse, had been sued for financial abuse. Through that case, I realized how vulnerable elders are, and from that point forward, I decided I wanted to continue handling elder abuse litigation cases, but I wanted to be on what I consider the right side of the case. I want to be on the side of the elder and their families. What's kept me involved in this case is I have realized through my experience in these cases how vulnerable elders are to being taken advantage of, to being exploited, to being neglected. They're similar to children in that regard, but in today's society, children get a lot of attention, and rightfully so, but elders, when they are exploited or abused or neglected, oftentimes they are pushed to the side. And they need not only many voices outside the legal community, but the elders need voices within the legal community. These people are very vulnerable. They've lived life the right way, and they deserve to have respect and dignity throughout their entire life. And so through law, we have a unique opportunity to really help elders keep what they rightfully earned and worked hard for as America's greatest generation. I'm very honored and privileged to be part of this distinguished panel and talk about financial elder abuse today.
Joel is rated AV Preeminent by Martindale-Hubbell, that organization's highest legal rating for ethical standards and legal ability. He has also received Consumer Attorneys of San Diego's prestigious Outstanding Trial Lawyer Award and several President's Awards. Joel was selected to San Diego Super Lawyers in Elder Law in each year 2012 through 2015 and has been recognized by the San Diego Daily Transcript as one of San Diego's top attorneys. And with that, Joel.
Good afternoon. Hopefully some of these facts from that hypothetical sound familiar to you. It wasn't difficult for me to come up with this hypothetical. Rarely do I have a case where we have all of that, although I have one of those right now. But these are the kind of cases that I deal with. Frank Fox, the prior speaker, most of his is the commercial, which is against insurance agents and financial advisors. I have handled those cases, but the bulk of my cases are the family, friend, so-called friend, I guess, neighbor, people who know the elder well and the elder really trusts them. A couple of things. I'm the third speaker on financial elder abuse, so there are I'll hear some things like, oh, that's on one of my slides. So there's certain things I'm not going to reiterate. I may mention again to the extent it fits. The number one takeaway from today, and we'll get to that, is undue influence. The vast, vast, vast majority of financial elder abuse going on out there is not someone taking advantage of someone who lacks mental capacity. In California, the hurdle to clear to be a person who has mental capacity is, about the height of an ant. You really don't, you have to be completely out of it, have no idea where you are, who you are, why you're there to be incapacitated. Those are slam dunks. Those are easy cases. Those cases might be handled criminally. The rest of it, the only hope is civilly, and we'll talk about why that is. We'll start off with stating the obvious. It is a growing problem. It's not going away. It's just this demographics. Again, you've seen some of these statistics already. Over 500,000 elder Americans suffer financial abuse every year. Again, that's based on the reported cases, so it's generally under. You've heard this figure of 3 billion all the way up to 39 billion. You know, something which a lot of people forget is down here that abused seniors are 3 times more likely to die sooner than a similarly situated elder who has not been the victim of financial elder abuse. That same victim of elder abuse, financial elder abuse, is 4 times more likely to end up in a nursing home. And that's what some people don't get, this connection between the financial abuse and the effects on their health. Why? Again, I believe Frank and Kelly both talked about how financial security is very important to people as they get older. That gives them peace of mind. When someone takes that, they're taking away their peace of mind. That is, frankly, between that and their health, oftentimes that is the bulk of what they have left at that point in their life, is they've worked hard. Now I can relax and, quote, enjoy my retirement. Once there's money, their money is gone, then there's stress, anxiety, embarrassment, depression, and we don't need to be medical doctors to know that all of those have a serious effect on our health, let alone someone who is already up into their elder years. So that's something that people really need to be aware of. The common offenders, again, that I deal with, family members, caregivers, I see that. Someone comes into the home. Why are they a common offender? Because they have access to the elder. They have the trust of the elder, particularly where the elder's family may not be around, and instead the caregiver becomes their family, which that's okay. It's not okay when that caregiver starts to exploit them financially and take advantage of them, take advantage of the trust they have. Neighbors, friends, this younger spouse or girlfriend, in the hypothetical here, again, Sally daughter is under the impression, hey, this is my dad's girlfriend, as she will later learn based on Ann Park's interview. No, really, it's actually his wife. And I've had that a couple of times where son or daughter gets concerned. They call the police in one instance. The police come, and my client, the adult son, says, the police are like, why'd you call us? Like, well, I'm here, I want to see my dad, and his caregiver, who lives in the guest house in the back, won't let me see him. She won't ever let me speak to him. And then caregiver goes in the back, produces a marriage certificate, and they had been married, 4 months earlier. That's generally a pretty good red flag. What is civil financial elder abuse? Again, I'm not going to get too legalese on you, but it's in the Welfare and Institutions Code. The real takeaways there are, what is it? Takes, obtains, or retains real or personal property of an elder, either for a wrongful use or intent to defraud. Intent to defraud kind of means what it says. I'm trying to commit fraud against this person. I'm saying one thing, I'm doing another. I'm trying to con them. For the wrongful use, this is really where my cases are. Wrongful use under the law is, look, you took an elder's property and you knew or should have known that taking their property, and again, that would include money, which would be personal property. You take money, real property, other personal property from them, in a situation where you knew or should have known it would be harmful. The reality, it's a rare circumstance. I can't come up with one when you took something from the elder without their consent and it wasn't harmful to them. So fortunately, the laws are changing to make it a little easier to prove financial elder abuse under the civil laws. Again, civil financial elder abuse, forget the legalese, takes property of an elder without the elder's consent. And you can take it via a will, an amendment to a will, a trust, an amendment to a trust. In other words, it's not just going over there, taking money out of their bank account or getting access to their financial account. It can be an instrument. It can be, again, in my line of work, wills and trusts. These amendments at a time when they have dementia. I've seen the proverbial deathbed amendments where the entire family's disinherited and the newfound friend Jim, who's been mowing their lawn for the last 6 months, gets everything. And you know, you think it's outrageous, but I bet you all have seen things way more outrageous than what I've seen. The next, again, this I wanted to emphasize, a lot of people, again, this is reiterating, you can take their property by way of an agreement. An egregious contract would be an example. In Frank Fox's examples, these annuity contracts, you are taking property of an elder via an agreement. So it doesn't just have to be you physically take it. The people have asked, I don't know how clear it is, we have 4 elderly ladies here with birthday hats on. People have asked, you know, who are they? These are all clients of mine who were all deemed mentally competent, but they were all very vulnerable to undue influence. And the proof of that is this picture was taken at a celebration of my birthday. We get together, they give me gifts, it's great. We celebrate my birthday 12, 13 times a year. That's the only funny thing I'll say. But it is to illustrate a point, which I'll keep reiterating. What is undue influence? We have a weird slide. The old definition of undue influence is something that really, no one really knows what it means, not even lawyers. It's still there, still in the civil code. Taking unfair advantage of an elder's necessities or distress. The other one, which until we had this beautiful new law a couple years ago, taking unfair advantage of another's weakness of mind. I don't know what that means, but certainly dementia, we could argue to most judges, look, this man or woman has dementia, taking unfair advantage. But beyond that, what undue influence is or was somewhat of a mystery. The new definition, the punchline of it is it's excessive persuasion with an unfair result. And it's worth for everyone to kind of go through, these are the criteria. So I'm in trial on a case right now, and it's really an undue influence case. Capacity, it's an issue, but it's really an undue influence. So in the case, we want to show the court, it's in a court where we are not entitled to a jury, so it's a judge. We want to show the judge facts which support these various elements, what we call them legal elements of financial elder abuse. You don't have to have them all, but these are the kinds of things that a court and a jury is asked to consider in deciding, hey, are these property transfers the product of undue influence? 1, vulnerability of an elder. Cognitive impairment, right? They don't have to lack capacity. I mean, there's a lot of degrees of cognitive impairment, mild, moderate, severe. At some point, they become mentally, they're deemed to lack mental capacity, but it's generally not until they're at least deemed to have severe cognitive impairment. Most of my cases, the elder is in either mild cognitive impairment or moderate. Punchline being, even with mild, they are still very vulnerable to undue influence. Influencers, apparent authority, there we're really looking at the relationship. Is this person their husband, their wife? What position do they have? Are they their attorney? Are they their realtor, someone who holds a position of authority over them? Is it their landlord? Is it their caregiver? 1 and 2, or A and B rather, I've heard expert witnesses refer to that. This is really, what kind of leverage does this alleged undue influencer have over the elder? because the leverage is a function of the undue influencer's or alleged influencer's authority as well as the vulnerability of the elder. And that's cognitive impairment and dependency. Do they depend on this person to give them all their medicine every day? Do they depend on them for all their transportation? Do they depend on them to read all their mail and pay all their bills? The more dependent, the more vulnerable. The more cognitively impaired, the more vulnerable. Actions or tactics used, controlling access to others and information, that's isolation, isolating them from others. In the hypothetical, I used to be able to call Dad and he'd answer, or the phone would ring and I'd get him another time. Now there's an answering machine with his girlfriend's voice and everything's changed. I'm no longer getting calls back. Ann Park comes to the door, says, hey, I want to meet with Frank. It's not so easy. Oh, Frank's sleeping and you can come back tomorrow. It's not like he's working or something. He's 85 years old. Why can't I do it now? They want to control the situation. In my biased view, probably have a time to prepare Frank for the interview. Remind him, your kids hate you. They want to put you in a nursing home. They want your money. I love you. Affection, intimidation, coercion. Most of my cases of undue influence are all about affection. It's part of their con, and that's what undue influence is. It's just another con game. It's just excessive manipulation. And although undue influence cases exist with coercion and intimidation, most that have come my way over the last 20 years that I've been handling elder abuse cases are affection. People trying to convince the elder, look, I'm the one for you. And they do some nice things for them, but they do it all under the idea that I'm using this just to get a lot of his or her money or property. Something on the affection, most of mine are, anytime there's a relationship between an emotional relationship, it's generally, in my experience, it is a woman unduly influencing an older man. I have had the reverse, and that's kind of the, I don't know what people call the Don Juan type thing. I had that case where he's 15, 20 years younger, comes in. She was kind of depressed already and, you know, was trying to be her everything up until the time she signed over her house to him. And that's someone, that person wasn't even cognitively impaired. She just had after reading her diaries and whatnot, she had severe depression, so she was an easy mark. And that raises a really important point, which experts in undue influence will acknowledge, which is you don't need cognitive impairment for undue influence. In the case I have in trial right now, the other side's expert, who is of some renown here in Los Angeles, admitted, yeah, people with no cognitive impairment can be unduly influenced. Again, if you think of the factors we have here, cognitive impairment is only part of vulnerability of elder. It's just one thing to consider. So that's important. But again, most of my cases, most of the cases you will see, the ones that you're probably gonna have to be able to show some at least mild cognitive impairment to ultimately have success. The one exception I have had was we could show severe depression based on a very detailed diary by my client. Equity of result. Was this fair? Case I have, 8-month marriage, $10 million going to the 28-year younger wife. What did husband get in return? I won't go into that, but very little. In this, so I've got presumptions of undue influence. I'm going to get that off the screen. Let's talk briefly about the hypothetical. Vulnerability of elder. Okay, Frank, we know he has some cognitive impairment, right? The mini-mental, granted, just a screening tool, just like a MOCA. These are just screening tools. To get the full picture, you need to know more. His daughter says he has dementia, but doesn't know if he's been diagnosed. That's something in the case we would ultimately try to find out. We would get his medical records, find out what's out there. Dependency, again, in the short hypothetical, there are some indicia of dependency. There is, look, she moves into his house, she's 30 years younger, she's now his power of attorney, she's now on his bank accounts, she's now on the deed to the house, she's now the sole beneficiary of his trust, it's her voice on the answering machine. You're starting to get the feeling, yeah, he seems dependent on her, he doesn't answer the door, she does. She controls the access to him and he's not doing anything about it. Fair to say he is dependent on her. Influencer is apparent authority, kind of the same thing. She's the power of attorney, the new wife. She has some, collectively as a result of all that, she has some leverage on him. And it's probably due to affection, which is one of the actions or tactics used. She's also controlling access to others, keeping others away from him. What information is coming out from him is coming in effect through her. You can't meet with him without me being present. You can't meet with him without me setting the appointment, that kind of thing. Initiate changes in property rights. That's where you see, the quick claim deeds. Here it's, I'm the power of attorney. I'm on your bank account. I'm in your trust. I'm on the deed to your house. That's the thing. Again, we're looking, the red flag one is this person in his life is now getting property, money from him for seemingly little or nothing in return. Equity of result, again, doesn't, this scenario, is that fair? Are most people going to think this is a fair deal? That she's in, she has been able to con him and convince him that his kids are against him and they just want to put him in a nursing home. I used those facts in the scenario. I mean, it is crazy. 90% of the time when we are able to dig down deep, we find that those two simple things are the same thing said in every case by the influencer. I'm the one who loves you, your kids only care about your money, and if I'm not here, I'm the only one keeping you out of a nursing home. Seems ridiculous. It's ridiculously easy to take advantage of our elders, and that's why we need everyone in the fight, because it is so easy. That's why it keeps happening, and it's going to be happening more and more because as more people get older and dependent on others. Presumptions of undue influence. All I want to make you aware of there, this is more legalese, but under the law, when one spouse obtains property from another, it's presumed to be the result of undue influence. So that helps us, because sometimes my client is deceased by the time the case gets to me. It's the deceased elder's adult children who are coming to me, so I can't interview him. I can't have him examined by a neuropsychologist, a psychologist, a psychiatrist, a neurologist. So the law recognizes that, said, yeah, these cases are kind of tough to prove, particularly when most of the elders are either deceased or demented by the time it gets to a civil lawyer. So in that situation, it's going to say, hey, wife, you take all that money from husband, or if it's the other way around, hey, husband, you took all that money from your older wife, you're going to have to prove to us that this wasn't undue influence. Other areas are when a caregiver gets a gift, gets money, gets added to a will or a trust, it's presumed to be the result of undue influence. And it's up to the caregiver to then prove it wasn't undue influence. And it's a big deal in courts to have to be able to prove it wasn't undue influence. So as lawyers, we look for these situations. Here with Goldie's a spouse, all of these transactions are presumed to be the result of undue influence. So that would really help us here. Also, this third one, it says fiduciary. Every spouse owes a fiduciary duty to the other. Who transcribed the instrument? That just means who drafted it. So if we were talking about the will, or I think he had a trust, well, Goldie didn't draft it, but her attorney did draft it, and that looks a little fishy. So we would argue, if she wasn't the spouse, say she was still just the girlfriend, we'd say, well, hey, Goldie, there's a presumption of undue influence because you brought him to your attorney for the sole purpose of drafting a trust which benefited who? Oh, wow, it solely benefited you. So we're going to say that's a presumption of undue influence. You caused this to be drafted. confidential relationship plus a gift of substantial value in exchange for no consideration or little consideration. All that means, is it a trusting relationship? Children and parents, that's a confidential relationship. Why? Because the law recognizes there's a lot of trust in that relationship, warranted or not. I'm constantly amazed as I get older how parents who've been ripped off, most times by their son, occasionally by their daughter, still at the end of the day can't believe they did it and don't want to do anything about it. So the law says, look, when you have this child-parent relationship, he ended up with your house, you didn't get anything in return, we're going to presume undue influence, and he's going to have to prove it wasn't. And it's, there's one case in particular, I had two in the same year, where husband dies, and it's almost always when one spouse is dead, because now they're more dependent, they're more lonely, they're more vulnerable. The family house in which mom and dad had lived in forever, dad dies, 2 years later, son has mom sign a quitclaim deed giving him the house. She doesn't really even know what that is. She signs it. 2 years later, he says, Mom, you're going to have to start paying rent. I mean, the house had been paid off years ago. Paying rent? What are you talking about? Well, I own the house, don't you remember? And she's like, I'm not paying you rent. This is my house. He institutes eviction proceedings against him. And that's what triggered them to come to our office. So she ended up with the house, and all kinds of nice things happened to him. How do we prove it? We've talked about this already. Medical records, bank statements, and in my cases, I hire expert witnesses, which can be neuropsychologists. If I have a living elder, I get a neuropsychologist to examine. They run through a battery of tests. We use geriatric psychiatrists. They administer some tests, psychologist, neurologist. It's not on there, but I have not used neurologists, but there was a comment made, I believe by you earlier, that in some courts they require a neurologist to come in and opine in connection with a conservatorship or these kind of issues. The thing, and again this talks about, reiterates, undue influence can exist without cognitive impairment. And what are you looking for in these documents? Unusual changes. If they've had a will or trust for their life saying, when I die, everything is going to be split equally among my kids, right? And that's pretty typical. Not always. Maybe they don't like their kids. Most people will still give them the benefit of the doubt, right? So they're going to split it equally among the kids. They're not going to show favoritism over one than the other. And then he gets dementia, and then the black sheep son moves in with dad because there's, his wife died. Well, why does the black sheep move in? Well, because he's got nothing going on. He's got no family, no children to worry about. Yeah, I'll move in. It's the best place I've lived my whole life. Been yearning to get back here for years. And then they get in there and they talk to dad daily. They eat meals with him. They get all this time to influence him, because if once black sheep son moves in, of course he doesn't get a job. He just hangs out with dad. Maybe gets him drunk. I mean, these are all things and cases that I've had. When I think about these, aren't tough. I don't have to be creative. They're right out of cases I've had. So they form the relationship, and then voila, the trust is changed to black sheep son gets everything and the others don't. That's the kind of things we're looking for, patterns that before they had dementia, they did everything this way. This is how they wanted their assets distributed. They were savers, and then they get dementia, the influencer moves in, and they now start acting irregularly. They're adding people to their bank accounts they don't even know. They're changing their trust, that kind of thing. Those are the things to look for there. The number one point with neuropsychologists and these experts, why am I using them? What I'm using them for is to try to explain to a court or jury my toughest task, which is many of the elders who I represent could come in here, if you spend a short period of time with them, you'd say, hey, he seems like a regular guy. He's nice. He knows he was talking about the president. He's talking about the election. He actually still dabbles a little in the stock market. So you're saying, must be okay, cannot be unduly influenced. But nothing could be further from the truth. The reality is our brain's pretty complicated, as I've learned. And there's portions of the brain based on the way you've conducted yourself your whole life and these stored memories. You can fool a lot of people that you're okay, right?
hello, how are you? What do you think of the weather? God, seemed great, seemed on top of it, sharp even. But if you spend time with them and do these tests that are designed to test how certain other parts of the brain are doing, well, you'll often find like a case now where the neuropsych test says, oh, it still has a pretty good memory. He's 87, still has a pretty good memory, did well on these kind of tests, but in the area of tests which are designed to test executive function, which is judgment and insight, did horrible, well below norm. And again, undue influence, that's where it happens when we have a impairment in executive function. Undue influence is about judgment and insight. And the analogy I like to give, my boy is 12 now. When he was 8, he could talk to you about baseball, video games, and all that, and you'd say, oh, sharp young man. And you'd say, by any stretch of the meaning, he is competent. He generally knows what he wants and why. But should he be allowed to give away a house that he got from his grandfather, if that was the case, which it's not, fortunately. But everyone would agree that this 8-year-old shouldn't be able to give away his house and be conned, because an 8-year-old's very easy to con. And that's, unfortunately, as we get older, it's just some of us get there quicker than others on the cognitive impairment. When we have this impairment in our executive function, with our judgment and insight, we become very easily manipulated, very easily influenced. And that's what happens. But to the outside world, you still look at him, oh, it's 85-year-old Bill with all that life experience. But unfortunately, you start, like everything else, you revert back to childhood. But it's not so apparent. And so that's why we need psychologists, psychiatrists, neurologists to come in and help explain how they can function well in this part of their life, be a really easy mark in that other part of their life, because that's a different part of the brain, and that's where they have the impairment. Understanding undue influence. There's still a lot of attorneys that I come up against who don't seem to get this. The victim of undue influence is generally unaware they're being unduly influenced. Right? They're saying, well, hey, we talked to him. This is really valuable evidence. I'm like, of course, what do you think he's saying? The victim of the con, when it's happening, doesn't know they're being conned. If they did, they wouldn't do it. It's because they lack judgment and insight that they're being conned and are totally unaware. Were they happy the day? Was he happy the day he got married? Who cares? They think that's significant. He was happy when they got married. He must be okay to take all his money. Take the $10 million. He had a smile on his face the day of his wedding. It's like, look, of course he is happy. This was the tool of influence, affection. I love you. You're my guy. Your daughter just wants your money. They're so easily influenced. It's so easy. They fall for that line time and again. And so talking to the elder and say, hey, you being unduly influenced, are you okay with this $10 million you just transferred? I didn't remember that much, but look over the shoulder. Yeah, I'm okay. I mean, it really is that case. And I've had the victim of undue influence will typically defend the influencer. Same reason. They don't know they're being conned. There are exceptions, but generally in my experience, they don't know they're being conned. Interview the alleged influencer. And I only thought of this because in most of my cases, I do have an APS worker who is a witness. And in one case, which I'm dealing with right now, I said to this gentleman, I said, did you interview the so-and-so who's the alleged influencer? No, I just thought it'd be some self-serving stuff. I would just encourage you, interview them anyway. Maybe it will be a waste of time. There's stuff I do as a lawyer. We try certain avenues of questions. Sometimes it goes nowhere. Sometimes you get a gold mine, and this is why it's important. Because typically, APS gets involved, bless you, in a case, and then in one of my cases, this didn't really come to light till 5 or 6 years later. And the gentleman's dead, and his sister comes to me, and we like, was there an APS? I heard something about APS. We subpoena the records. We eventually get the records. We talk to the APS worker, and in this one case, I mean, typically 5 or 6 years later, among all the cases you all handle, maybe you're probably not going to remember the specifics, but you're going to look at your notes. And that's significant. I would encourage you all to take, particularly in a case that, hey, maybe this does blossom into a lawsuit someday, take detailed notes so that if you or someone else has to look at these notes, they'll have a pretty good idea who you interviewed and what they said. And always, 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 I encourage you, interview the alleged influencer, because they may say things, they're a little off guard then. By the time I get to interview them, so to speak, they've got an attorney and they're prepared, right? So you're the first line of defense, first line of offense, really, in my mind. Get very detailed statements to the extent you can. Ask them to produce documents. I know it takes time, but it is worth it. And again, being you're the front line, you're going to have the best chance at preserving really valuable evidence for whatever attorney ends up handling it, if it goes that way. This is a really big point which has been made by a couple people today. In that same case, when I interviewed the APS, and I actually deposed the APS worker, he was saying that when he was investigating this for elder abuse, he was saying, is this criminal elder abuse? As other speakers have said today, criminal elder abuse is really difficult to prove. The DA has his or her hands full with that. Financial elder abuse by the district attorney is typically the very obvious stuff. Caregiver took dad's ATM card and is on video getting $300 out of the account. It is not undue influence. Undue influence, the only way that can be prosecuted is civilly, and that's by the law. So keep in mind that civil is the path of least resistance. Undue influence is not recognized as a crime in California. I can't speak to other states. There was a case 10, 15 years ago, the DA in San Diego, who's an awesome DA, Paul Greenwood, maybe some of you have seen him speak, was ecstatic. Hey, Joel, we got a conviction based on undue influence. Well, Court of Appeal said no. No undue, it's not a crime, there's not enough intent. So again, don't be discouraged if you're only referring it to a criminal attorney, not a criminal attorney, you're referring it to a city attorney or a district attorney, the odds are that that's going to hit a dead end and there'll never be a prosecution. And the vast majority of elder abuse that's coming your way, nothing will be done. It's self-serving, but it is the truth. The civil financial, we have it a lot easier, and we are the path of least resistance. So when you have these situations, be sure to send it, even if you find inconclusive, send it to a local referral service, and ideally it'll get in the hands of a lawyer who handles these kind of cases and can tell the family whether there's anything they can do. We handle cases hourly and contingency. We're no different than other lawyers in this area. It just depends. So even if they don't have financial means, if the case sets up a certain way, there are lawyers out there with these referral services who will take them on a contingency, which means they take the risk, they get a percentage of what is recovered. The remainder of this really is just more lawyer stuff. In addition to the money, where the facts are right, the lawyer can get, as you heard from Kelly, treble damages. You can get, some lawyers will take the case because we can get our attorney's fees and costs back if we win, assuming the defendant has money. But civilly, there's all other things we can do to tie up the defendant's assets before they go run away and hide. So when we hear about it, often we will file with the court things called writs of attachment or lis pendens to freeze accounts or freeze the property to ensure that if we are successful, the elder will actually get their money and property back. And criminally, I'm unaware. I don't believe they have similar options. And what I found in the criminal setting is often if the defendant has money still, it all goes to their criminal defense attorney because they want to stay out of prison, which is, you know, the person needs to be put in prison where they can do it. But again, undue influence case, not going to happen. In closing, I just want to reiterate that you all are the front line. And again, I think it's offense. Keep the things in mind that I've said. I mean, these reports you guys fill out and put in your files are really important. There's a big difference between inconclusive and unsubstantiated. Because again, you may be gone, we can't find you. And the other side on the defense will say, they looked into financial elder abuse and it was unsubstantiated. Unless you have evidence that there was no elder abuse, I would just encourage you to go inconclusive. Because in the cases I've had, the investigation was, okay, well, I talked to so-and-so, and he didn't have any complaints. And I realize there's restrictions put on you in terms of what you can do and all that. But again, encourage you, ask for documents, create a record so that if it becomes a civil case, some attorney will at least have a beginning and will have some of the key documents in hand, which often disappear between the time you all investigate and the time that an attorney gets it. And it's like a lot of things in life. I think we face a lot of decisions in life where we can be part of the problem or part of the solution. All of you, as evidenced by you coming here today to learn more about this, are certainly part of the solution. And keep being part of the solution and keep trying to be a bigger part of the solution. I appreciate your time. Thank you.